Well, ladies and gentlemen, I wonder if you could resume your seats and we will get underway again. We just heard from Dr. Baltz-Gross about the increasing trend towards specialist arbitration and how attractive that is in a market that we've heard is competitive, where clients for arbitration have their choice. We're now going to hear from Eric Wilbers. Eric is from the Netherlands, whose football team is playing disturbingly well in the World Cup. He is the director of a tailor-made arbitration center, the Arbitration and Mediation Center of the World International Intellectual Property Organization in Geneva. So patents and law, he's the Einstein of arbitration, and he's going to tell us the recipe for a successful specialist tribunal.
Thank you, Michael. Okay, so indeed, we are hearing this morning, this afternoon, about trends in international arbitration, and part of that perhaps is how arbitration is growing in different directions where it wasn't before. And as Michael was mentioning, intellectual property is one of those areas, and this is what I'll be addressing in the next 10 or 15 minutes. I'm doing that with these slides, and I hope that you can see them from where you sit. So the mission, so to speak, of this particular arbitration and mediation center is to to actually bridge the gap between ADR, alternative dispute resolution, and intellectual property. And WIPO does that by offering services much like other centers in arbitration, expedited arbitration, mediation, and also expert determination. Now, there are many arbitration centers in the world, and we've heard about some highly successful ones, such as those in the Far East at the moment, and more traditional ones in London, New York, other locations, Paris, certainly. So what is special about this particular center? How are we somewhat different? The first one is in our own specialization in IP. And that comes out primarily in having access to and working with neutrals, arbitrators, mediators, experts that are intellectual property specialists, in addition to knowing their way around ADR. The second, perhaps rather special aspect of the WIPO Center is that we are international. And this is truly so because we are an independent part of an international intergovernmental organization. So we are not rooted in any particular jurisdiction. We have offices, physical offices in Geneva, where WIPO sits, as well as in Singapore, which is quite fitting given the presentations that we've heard so far. Now, this presentation really isn't so much about WIPO. I would like to focus more about this link between one area of commerce and a growing one, which is intellectual property on the one hand and ADR on the other hand. That's really what I would like to briefly address. And so, what is special about intellectual property that it qualifies for more ADR? What is that link between IP and ADR, really? I have on this slide put 4, 5, 6 factors. I will call them out very fast. The first one is something which is, I think, generally acknowledged, which is that the cost, the growing cost, sometimes prohibitive, of litigation, especially international litigation in the courts. That in itself is a development that also very much affects intellectual property, especially in patent disputes. And if I can just fast forward by one slide, you will see here, you will see on this slide statistics that show, and this is already a number of years old, the cost of litigation, including patent litigation, that is the highest bar on the right, the patent litigation in the United States. If you look at the absolute figures, you're talking about averages of running between $3 and $5 million, and this statistic, as I said, is not the most recent one. So if you keep that in mind, you understand that parties in intellectual property increasingly try to avoid the courts, except if you need to set a precedent or don't have other jurisdiction. A second link between IP and ADR is that intellectual property is increasingly international. It is almost exclusively international. The cost and effort of obtaining patent protection is such that you would be well advised, of course, to seek back your investment by going abroad. Products are no longer just being produced or researched or distributed or protected nationally, it's internationally. And with that internationalization of IP comes, of course, an increased interest in ways of solving disputes that go across borders. The third factor, the third link between IP and ADR, I would suggest is, and we've heard it back in financial disputes, I believe just now, M&A, is the very specialized nature of many intellectual property transactions. Here you can talk, for example, about patent licenses or certain R&D agreements. These tend to be so specific and technical that parties tend to appreciate the possibility that ADR offers to appoint a neutral, an arbitrator, who is specialized in that particular area. That's a specialization which unfortunately is usually not quite available from the courts. I'm generalizing here, of course. Another factor in the link between IP and ADR is intellectual property is a fast-moving business. We are buying one smartphone, and half a year later, we already have the next generation smartphones in our pockets. And so producers don't have that much time to exploit their intellectual property. Hence, they're interested in procedures that can go faster and that they can more or less control in process. And that is ADR. Confidentiality is another factor in intellectual property, whether this is about consumer reputations with consumers in the area of trademarks, or whether this is about the technology behind patents, know-how, trade secrets. It's very important for parties that are in IP and that have disputes that those data remain as confidential as possible, and ADR tends to be a better guarantee of that than going to the courts, obviously. Let me move on and explain, just illustrate some of this by a couple of statistics. Too much information, I think, from where you sit on this particular slide, but the bottom line is that more than 50, just about 60% of WIPO disputes, WIPO ADR, is actually about technology, is about patented technology, or is about information technology, which we also saw on another slide earlier. What type of agreements do we find in our cases? What types of agreements hold these WIPO clauses? As I'm sure they are also holding other clauses these days. A rather standard type of agreement which we see at WIPO is a license. It can be a patent license, a trademark license, something with copyright, some IT systems. That is quite a standard source of ADR cases. And that is, of course, true, especially when it comes to international agreements. But then there are so many others as well. Trademark coexistence agreements. How do you divide up the lines between using similar or identical trademarks internationally? And what if that goes wrong? Do you then go to the court? If so, to which court? ADR, again, quite a common alternative to that. I should note that these are contractual arrangements which therefore can include a contract clause, an ADR clause. However, there are also cases, they tend to be rare, there are also cases where ADR is used between parties that do not have a prior contractual relationship, but do have a dispute, usually on the basis of an infringement allegation, and will then conclude a submission agreement to take the case to ADR. That happens as well, but it remains the minority. I would like to zoom out a little bit from the WIPO experience and talk to you a little bit about the survey which we have held. It was fairly extensive last year, and in case you would like to know more than the slides, the 4 slides that I'm offering, you will find very extensive results and a report on the website of the WIPO Center. What did we do? We surveyed about 400 parties, large corporations around the world, some government agencies, for example, in R&D, and certainly also some of the larger law firms operating and answering on behalf of certain of their technology clients. We asked them about their practices and desires in the area of technology dispute resolution. And it's quite important to note that the makeup, the composition of the participants in the survey was very, very international. In fact, 9 out of 10 participants reported to conclude regularly international agreements, which doesn't, which is not particularly surprising, perhaps. But what you can also see is that 8 out of 10 actually concluded agreements having patents or other types of IP rights outside their own jurisdiction. So truly across the international board in technology. And this was I hope it's not too small for you to see this, but one of the core questions that we asked was, what are your principal considerations? What is your biggest motivation in making the dispute resolution choices that you do? Why do you take the courts? Why do you take ADR? What is it that you're looking for when you have a dispute? And the vast majority of participants in the respondents in the survey actually replied that cost and time were their biggest motivating factors. So unlike what one would perhaps, including as a lawyer, expect, the quality of decisions, the fairness of the outcome, even the enforceability, all of that took a backseat to time and cost. Time and cost were the biggest factors. I think it's very important to bear that in mind going forward. Of course, parties also care about all sorts of other factors in this. They want the right results, but the right results don't seem to help the parties very much if they take too long and too much money to achieve. Now, another question that we then asked is, okay, so if these are your motives, how do you actually resolve your disputes? What methods do you use? And on this slide, again, a little bit hard for you perhaps to see, but all available online, is that to the right of this bar is the most frequently used method. And in this case, unsurprisingly, that is direct party negotiations. But pretty soon afterwards, you will already see that parties use court litigation. And parties will first use domestic court litigation more frequently than international court litigation, which makes sense, because international court litigation, of course, is more expensive, etc., just a bit more scary, as we've heard. And so those negotiations and court litigation are by far the most used techniques. ADR, arbitration mediation, follows all the way on the left of the chart, which means the lesser used ones. If you want some absolute numbers, you will find them again in our report. And so it's important to bear this in mind when we are looking at the next slide, which is, well, if this is how you resolve your disputes, how much did it take in time and how much did it take in cost? And so the procedures, the choices that cost the most in time and in money are actually here on the right of this chart. And what you can see is that court litigation, unsurprisingly, especially foreign litigation in courts, is by far the most time-consuming and the most costly. Arbitration and mediation follow at a long distance from that. There's a very, very big distinction in the time and cost between court litigation and ADR. And that's interesting because, again, if I may recall, going back to the previous slide, how are your disputes actually handled in practice? You see that court litigation is still by far the preferred method, at least the most used method, whereas what about the time and cost? It turns out that that most used method is actually also the most expensive one and the most time-consuming one. So this, of course, suggests a few lessons, and I've tried to articulate them on this particular slide. The first lesson that we see from this survey, at least as it pertains to international contracting in technology, is that one should really have a dispute policy a contract policy that anticipates disputes. Disputes are nothing exotic. Disputes are really part of doing business. They are part of the cost of doing business. So you have to be prepared for that. You have to take your clauses very seriously, your contract clauses, your dispute clauses. Now, in your dispute policy, how do you approach disputes and what are your contract clauses and when do you go to court and not? It's very important to understand that there's likely to be an international angle, either in the parties that you're contracting with or in where your rights are being protected or the applicable law to the dispute. And so that's to be borne in mind again. And then a third lesson that comes really out of that first chart that I showed you from the survey is think about time and cost more than anything else in the dispute choices that you make. If you don't do it at the beginning, you surely will towards the end of your dispute when you will try to settle it and possibly regret some of those earlier choices. WIPO advice, WIPO experience is parties really appreciate mediation. We are very much into arbitration. Arbitration is about 60% of our cases, but mediation tends to be very much appreciated as that opportunity to settle earlier for less money. And it's also to be understood and to be noted that many arbitrations, in fact 40% of WIPO arbitrations, also settle before the end, before an award. Then between court litigation and arbitration, arbitration tends to be the faster and cheaper one. Perhaps the latter, the cheaper, is somewhat surprising because you have to pay the arbitrators, but you make that back in the time and the cost of the rest of the procedure. And so, for example, also the absence normally of an appeal procedure is a big cost saver as well. A few more lessons here. There is certainly scope for ADR as well in non-contractual disputes, trying to make a bigger effort to get the other party to agree to using ADR. So I thought these would be some relevant results for all of us that apply in intellectual property, but possibly also outside, to bear in mind when thinking about dispute policy. And the lesson from WIPO has definitely been that more even than before, we really look at the time and cost of our proceedings. We work very actively together with our arbitrators, with our mediators, because we believe that it is really the duty of the neutrals to listen very carefully to the interests of the parties in terms of as fast as possible and a cost-effective procedure, especially internationally. I think I'm running out of time, so I will leave this slide for what it is. What I did here is list out another perhaps 10 or so general developments in arbitration, which I think speak for themselves more or less and go beyond intellectual property. If anybody would like to have these slides, I'm sure the organizers could help you to them. Otherwise, drop WIPO an email and somehow they will come to you electronically. I'll be very happy to share them. Maybe I'll show you just one bit that goes back to these 10 arbitration developments generally. The increasing use, of course, of electronic media, of electronics, of online facilities, of databases as well. In our larger cases, especially used at WIPO, arbitration cases, parties tend to appreciate having an electronic case facility which we make available, where all the exchanges are handled through a secure online facility that parties can use. It's especially used in cases where you have more than one party, teams of lawyers in different locations, or very heavy on evidence, many submissions. And so in those circumstances, a system like this is really appreciated. I'd like to leave it there. Thank you very much, Michael. I have to leave it there. Thank you.
Eric, thank you very much. Again, I wonder if we have any questions from the audience for Eric. It's a very good opportunity to ask about a specialist and very successful arbitration platform. Does anybody have any questions? No? In that case, one from me. I'm not an intellectual property lawyer by any means. I understand, though, that the German courts are very popular within Europe for intellectual property disputes, and I know that the English courts have lost a lot of business to them. Do you regard the German courts as competition for you? And if so, how can arbitration gain the advantage?
Thank you, Michael. Let me maybe say a reply which might be mildly controversial in the company of fellow arbitration lawyers, but if the court functions well, I don't really feel a burning need for ADR to compete with them. I think it's really up to the parties. I'd like to think that arbitration and ADR should perhaps refrain from trying to make itself attractive by comparison to the courts exclusively. Of course, I mentioned myself a little bit about the sometimes prohibitive time and cost and risks, substantive risks associated with court litigation, especially internationally. But that is not really the main reason why I think parties have to believe in ADR. There are many more reasons than that. And if the German courts are effective in intellectual property disputes, which I'm sure holds also for other areas of law than intellectual property, then I believe they mostly deserve to be congratulated. One would almost wish that in that case every court would be a competition like that. In the end of the day, though, I think it's less the quality of the courts that matters. I think it's really more the internationalization of commerce that is driving our business. Thank you.
Thank you for that. I think Lord Hoffman has a comment too.
Just wanted to point out that the German courts have the advantage of being quick and relatively cheap compared to the English ones. But the problem about arbitration, at any rate in patent law, is that an arbitrator cannot revoke a patent. Most patent disputes involve a claim of infringement on one side and a counterclaim to revoke the patent on the other. And this is beyond the jurisdiction of any arbitrator.
I think Eric wants to respond on that.
Predictably, not entirely by agreeing, but just to add something here, that if we look at the WIPO cases, just as a measure of what Lord Hoffman is mentioning, the question of arbitrability of patent disputes has actually rarely, if ever, arisen. I think it has arisen in a handful of cases over time, which may sound surprising, but actually it isn't perhaps, for two reasons. The first one is that it is generally acknowledged, including in some interesting ICC awards, which had Germany and Japan as angles, that arbitrators, of course, have jurisdiction to decide the dispute, at least between the parties themselves, which is often what they really care about. Often it tends to be about, in the area of patenting, it tends to be much more about damages than about, what is the exact status of the underlying rights. And the second reason why we see so little of this arbitrability issue is that, of course, most of our cases, more than 95% of our cases, and that's typical in arbitration, tend to be on a contractual basis, tend to be between parties that have a contractual relationship. And where that is the case, these parties tend to, not so much in our cases at least, they tend to be less focused on attacking each other's intellectual property, because they have actually been using and respecting and contracting for that very intellectual property for years. So the question of arbitrability is one that would arise, of course, much more likely in a third-party context where you're dealing with infringers who will immediately challenge the quality of the patent. That is something which perhaps happily is much, much less of an occurrence between contractual parties.
Thank you for that. I know that Dr. Gross has a comment too. Perhaps he'd like to come in shortly.
Yeah, thank you. I understand that. Just one real-life experience. I had an arbitration on the license agreement. In every arbitration and license agreement, there's the objection of the invalidity of the patent, of course. And in parallel to that, a Mannheim court litigation with regard to the same patent. Of course, a conflict of jurisdictions. But what happens in Germany, if you have that kind of dispute, that is, the Mannheim court has to refer the patent validity issue to the Munich court, of course. So stops partly its proceeding. And because these two proceedings were running in parallel, you could see that the arbitration was conducted in approximately 17 months. And at that time, the German proceeding was still very much on the way. So I think this is a very good example to show how cost-effective and time-effective the arbitration, a WIPO arbitration or an ICC arbitration could be.
Thank you for that. That's very helpful. Thank you, Eric. Thank you, Dr. Gross. We're going to move now to a completely different field of investment arbitration, which in terms of the scale of cases accounts for some of the biggest arbitrations around the world. We're going to hear about this from Klaus Reichert, who is a senior counsel at the Bar of Ireland. He practices in London. He's got extensive arbitration experience in many fields, and I noticed that he's a member of the International Basketball Federation arbitration panel, though evidently not of the FIFA football panel, and hence he's here with us. He's going to talk about investment treaty arbitration.
Thank you, Michael. I hope everyone can hear me clearly. It's a particular privilege for me and an honor, and I'd like to thank the organizers for being probably mad enough to invite somebody like me to come and speak to you. This has given me an opportunity for my first visit to Russia, and I can think of no better room in the world with no better view to conduct an arbitration. And from now on, St. Petersburg and this room shall be my direction in all my cases. I hope parties will follow that. Before I come to my points on treaty arbitration, I'd like to pick up on a couple of themes that were discussed this morning. And as regards the overall theme about arbitration in the 21st century, and in particular, arbitration developments here in Russia. In preparation for this, I spoke with a client of mine who has a large number of joint ventures in a particular industry dotted around the globe. And I asked them, what was their rationale for choosing a venue for arbitration? Because so many countries now have excellent arbitration laws, they have excellent facilities. Lord Hoffman mentioned Mauritius has excellent facilities, excellent law. Singapore, my home country, Ireland, we spent a huge amount of time renovating our Arbitration Act some years ago. But my client gave what I would describe as a very interesting, practical and client-focused answer to the question I posed to him. They choose a seat where they know they can bring their own lawyers from wherever in the world to do the arbitration. That's a given, and every seat will pretty much have that. But they're also cognizant of the fact that there may be court processes afterwards at the seat. And they want to have the assurance that there are a sufficient choice of excellent local lawyers conversant with the international arbitration process that they can use for any court challenge or resisting a court challenge. So for any seat, I would view it as critically important that the local bar and the local lawyers really invest themselves in learning about the international arbitration process so as to present a choice for international parties arbitrating in that country. Because, and this is the key client point that he gave me, they will not go, this client of mine will not go to a country where they believe or have the perception that there is a tiny local expert bar and effectively they would be captives of a tiny number of people. They like choice. So perhaps that's a take-home for this, for you and for countries who seek to develop arbitration, to make sure that not just the legal architecture is there, but the perception that the personnel on the ground to represent foreign clients in courts afterwards is there as well. Now, I'll move on to my presentation this afternoon, and I describe it as a window of opportunity in investment treaty arbitration. Now, why do I say that? Well, about a year ago, an august body called the United Nations Conference on Trade and Development, much handier described as UNCTAD, came out with a very interesting report, and I commend it to you. They have said and pointed out of the 2,860 approximately bilateral investment treaties that are in place at the moment, more than 1,300 are currently at the stage, literally as we sit here, where they could be terminated or renegotiated at any time. So they've effectively come through their initial lifespan, and either state, either sovereign on either side of these treaties, could decide to terminate them or renegotiate them. And in fact, between now and 2018, at least 350 treaties will be coming to the end of their initial duration. So there's an extraordinary period where a large number of these treaties have gone through their lifespan and are now at the stage where they could come to an end. They could come to an end by simply inaction, or more critically, and this is where I see the window of opportunity for treaty arbitration and the international investment law generally, is that it's now the time for sovereigns, because ultimately the contracting parties to these treaties are the sovereigns. They're not the arbitration lawyers, they're not the investors, it's the sovereigns. They are the people who hold effectively the steering wheel to these things. They are now at a point where they can either be terminated or renegotiated. And one actually is starting to see it now, where there are ongoing negotiations between major blocs in relation to free trade agreements. There's discussions between the European Union and Canada, between the European Union and the United States. And these actually have brought arbitration very much into the mainstream, as opposed to sitting somewhere remotely in the background. Now, I think this is an opportunity for a new focus in international investment law and an opportunity for new focus on arbitration. I think every country that is a party to treaties, and particularly maybe the countries that have been respondents in cases and may feel a bit bruised by what has happened over the last 10, 15, or 20 years in relation to investment treaty cases, is to focus on the rights that have emerged from the treaties and that have been revealed in the cases. I think it's time to take stock. I think it really is incumbent on all states, and perhaps the citizenry of states, to focus on what has happened and to take stock now and look and take the opportunity of so many treaties coming up for either expiration or renegotiation. I think also there's an opportunity, and the European Union has been doing this, to focus on the dispute resolution mechanisms in the BITs. People complain about arbitration, but I think it's important that there is a sober and reasonable debate so that the people become informed as to how exactly the obligations that sovereigns enter into are adjudicated upon. Now, it's important, and I'm afraid one has to say the occasional inflammatory point, but I think it's important to say this, that there is a conflation and a risk of conflation amongst the international arbitration community between the process of arbitration and the actual substantive rights in international investment protection law. Sometimes one feels that international arbitration lawyers are pulling them all together and will discuss, for example, the content of fair and equitable treatment clauses in the same breath as they would discuss the procedure in arbitration. I think it's very important during this stage, during this 3-year window of opportunity, that we carefully take perspective on the process of dispute resolution, but the substantive rights created by these treaties, but also the creation of rights emerging from the treaty case law. Now, what is the opportunity, and the opportunity to do what? Now, UNCTAD, in its report last year, said this is an opportunity to address inconsistencies. Now, depending on who you would listen to, the inconsistencies can vary wildly, but perhaps now is not the time to get into the granularity of what has emerged, but really to step back and take perspective on what the states should seize upon over these next few years. For me, my suggestion, and my very humble suggestion, is that it is an opportunity for states to consider whether the rights which have emerged in the case law are indeed the rights which they as sovereigns wish to accord to foreign investors. But there's a converse point to that. Many countries now, and it's not just the traditional Western capital exporting countries of 30 years ago, investment flows are coming from all over the world. If one takes a peek into any major newspaper or major journal of economics or investment, one will see that it's not just now the Far East, but sub-Saharan Africa, for example, is one of the major growth centers with a huge outflow of investment all over the world. So there are, I think it's incumbent now on all countries who have these sort of treaties to look at what their nationals need as outbound investors, but also what sort of rights that they wish to accord to foreign investors. I think now's the time for the sober debate. I'll wrap up rather, I suppose, with the another perhaps obvious point, but maybe it needs to be said. We don't want to judicialize diplomacy. That is a very bad thing to do, because that actually, I think, detracts from the legitimacy of international investment law, and also brings unwarranted and, dare I say, untoward attention on arbitration as the dispute resolution mechanism, because there's collateral damage by a perception that the rights under treaties are too extensive for foreign investors, therefore the whole system must be pulled down. I think we have to be very careful to ensure, and as citizens of countries, I think what we need to do is go home to our respective countries and engage insofar as we can with our respective governments and say, we wish you, during this window of opportunity, to really work on a sober analysis of our treaties. What should we do? What sort of renegotiation should we have? Should we recalibrate? Should we terminate? Should we bring in new treaties? Should we have more detail in these treaties about the rights of foreign investors? But ultimately, this is for the sovereigns to agree amongst one another, because the judicialization of diplomacy, as may have occurred over the last few years in the course of treaty cases, perhaps I would say is not a good development. And with that, I thank you for your attention.
Thank you. Does anybody have a question for Klaus Reichert on investment treaty arbitration? In that case, I do. From what you said, most investment treaties are now old, and they were therefore concluded in a different era. And probably it's fair to say that they were concluded between developing countries and developed countries. And possibly also, and this is really the question, the jurisprudence that has developed around them tends to give pretty absolute rights to outside investors rather than simply preventing discrimination against outside investors compared with domestic investors. Is that a fair impression? And in any renegotiation of investment treaties, do you think that we'll move more to an anti-discrimination model rather than absolute property protection?
Thank you, Michael. I'll answer the question in two ways. A light was thrown on how many treaties have come into being by the former Attorney General of Pakistan in an interview he gave to Global Arbitration Review in the last while, where he said many of these treaties, in his experience, were simply nice documents to be signed between pretty unwitting governments who wanted to have something as a result of a visiting president or visiting prime minister. And these agreements looked rather good. Nobody really gave much thought to them. So I think perhaps the foundation of many treaties is states wanting to do something that looked rather nice, but without giving much thought to them. As regards the future direction of treaties, I'm not sure that the actual case law, when you actually dig into it, is necessarily as favorable to investors as the perception might give the impression of, because I think what's happened is the occasional case where an investor has been accorded extraordinarily indulgent rights by a tribunal is perhaps given far more prominence amongst the drumbeats and the jungle drumbeats of the arbitration community in the endless blogs that go around about treaty arbitration. But when you actually dig into a lot of the case law, the tribunals tend to be quite rigorous about this. However, I still feel that standards such as fair and equitable treatment and most favored nation clauses do give an extraordinarily wide berth to tribunals to do things that perhaps the states did not necessarily intend. And that is where I think authoritative interpretation between two sovereigns over the next while, if they wish to continue a treaty in place, may be an important step for them to take, to say, this is not something we want. My final point on this, just by way of wrap-up, is I was at a seminar in the last week in Frankfurt and listening to one of the chief negotiators from both the European Union and the United States. And they said that actually currently China, in its treaty negotiation program, is seeking very extensive rights for its nationals as they invest abroad. So that's actually quite an interesting dynamic, that they are looking for precisely the sort of pretty much you can't do anything to us sort of rights for their nationals as they invest abroad. But I think this is the emerging dynamic, and the emerging dynamic from the change of investment flows in the world.
Thank you, Klaus. Thank you very much. Our next speaker, I'm sorry, I missed a question at the back. Could we have the microphone to the back, please? Just over there.
Thank you very much. Just a very simple question. I'm very interested in the presentation that you made, whereby you mentioned that countries are now revisiting and negotiating the existing bids. And sorry, I forgot to introduce myself. I'm Chaya Muzar from the Indonesian Ministry of Law. And I would like to know how would you see the approach of the European Union? For example, Indonesia is thinking to renegotiate the existing treaties, especially with some of the members of the European Union countries. And the response that we received that they are unable on an individual basis to renegotiate treaty with Indonesia due to the fact that now they are bound by the regulations that every treaty or every renegotiation of a treaty should go through the European Commission. And this is a very confusing situation for us. I don't know whether any of you from the panel would be able to address that issue, how Indonesia would be able to renegotiate of a treaty if the treaties that we concluded with the individual European Union countries were treaties that we signed prior to the establishment or the existence of the European Union. Thank you.
You have actually identified a rather unseemly family row within the European Union, where there is where the European Union, and particularly the Commission, effectively wants to eliminate all bits involving European Union member states and take over full competence for trade negotiations and trade treaties and investment treaties and make it the exclusive competence of the European Union. That's fine insofar as it goes, and it is actually confusing for those of us in Europe. We simply have really no idea as to who's going to do what. And what is also happening is national member states are getting involved, particularly the more powerful ones, are getting involved in European investment or free trade policy, particularly recently when 360,000 people in Germany signed a petition to say that any free trade agreement with Canada, between the European Union and Canada, should not include arbitration. And the German trade minister has said as much in a recent interview in Die Welt. So I'm afraid there's going to be rampant confusion in Europe for the foreseeable future. I'm so sorry I couldn't give you a clear answer, but then again, we're all lawyers, and clear answers are perhaps not our thing.
Thank you, Klaus. A clearer answer can, of course, be provided for substantial fees. Our next speaker is going to address a general issue. He is Christian Albanese. He's managing counsel of the ICC. He was so popular in this field that he was stolen by another panel before our break, which was one reason for it, so that we could find him. He is here now. He's going to talk about corruption in arbitration.
Thanks, Michael. It's on? No. Yes. Thanks, Michael. Спасибо большое за приглашение для меня.
Thank you for inviting me. It's an honor for me to be part of this major conference. But as I said prior in the evening, I won't talk Russian. I will speak English, and my presentation will be in English. I just wanted to say a few words in Russian. Thank you.
Going to our topic, I think what the idea of this panel was to address the trends and the current issues and what arbitration is going to be like in this new century. And I think there's one very important topic, which is the issue of the corruption and how tribunals had been handling these cases and how the tribunals have evolved since what they've done when the first case came to light back in 1963. So I'm going to discuss very briefly some, I think, 4 main aspects of this very important issue, which is precisely the issue of whether tribunals have jurisdiction, whether these claims are arbitrable, which in any event, it's part of the past. I think the answer now is clear, but I'm still going to mention that. And then I'm going to move on to 3 more current and practical issues, such as the standard of proof required to prove these illicit acts, whether the tribunals can, by its own motion, investigate these claims when the parties have not raised them as such, and finally, what are the legal consequences of a finding on corruption. So, going to the first topic, I think, as I was saying, initially, corruption seems to fall within the jurisdiction of the tribunals. At least that is what Judge Lagergren back in 1963 said in a very well-known award. The case involves an Argentinian agent that was passing on bribes to state officials in Argentina in order to win a contract for an English company. So there is a very interesting quote from the award that I'm going to read. It's very brief, but it says that Judge Lagergren, who was the sole arbitrator in the case, declared that having allied themselves with corruption, the parties had forfeit any right to ask for assistance from the machinery of justice, and therefore he declined jurisdiction. So the decision was mainly criticized because it ignored the principle of the separability of the arbitration agreement and the contract itself, and it mounted to considering that because of the corruption existing in the main contract, then the arbitration agreement was also tainted by it, which in principle would not necessarily seem to be the case. But as I was saying, this is now part of the past. Tribunals clearly take on jurisdiction. There's no questions about whether these claims are arbitrable. So it's part of the past, I think, but I thought it was worth mentioning how it all began. Now, when it comes to a more relevant question, which is what is the standard and the burden of proof required in order to make these findings on corruptions, what I've noticed through the revision of many awards from the ICC on this topic is that the trend is that there is no current uniform approach taken by tribunals. You see tribunals that will set a very high standard of proof, making it very difficult for the parties to be able to prove that there was obtained by bribes or by corruption, whereas you have other tribunals that, because of the considerations of due policy and the difficulty in proving that the contract was obtained through illicit means, they tend to lower the standard of proof. So I'm going to give you an example of a high standard of proof in a case, in an award of 2008. The tribunal stated that because of the seriousness of such a finding, the standard of proof should be higher than in any normal circumstance, requiring clear and convincing evidence beyond any reasonable doubt about the existence of a corruption. In this case, the tribunal found that the commissions, normally these kind of cases will involve an agent or some commissions or some state officials. In this case, all of that were present. The tribunal found that the commissions paid by the respondents to the claimant were used to bribe state officials in order to obtain a public contract. And to get to this finding, and I think this is interesting to give you an idea, a flavor of what are tribunals looking at, the tribunal identified the following 4 red flags. The first one was claimant's refusal to comply with the tribunal's order for him to disclose his bank and tax records, from the failure from which the tribunal drew adverse inferences. The second element was the lack of credibility in claimant's testimony that he was not able to produce these documents because his wife had stolen them. The third reason was that claimant activity as a livestock breeder and his lack of experience in the field of the contract could not justify the unusually high commission that he was perceiving. And probably the most compelling reason was that claimant was not capable of proving the legitimacy of several wire transfers made from his account to different relatives of one particular state official in this government. So on this basis, the tribunal found that the contract was obtained by bribes. Now, we have tribunals, as I was saying, that prefer to rely on circumstantial evidence or on faisceau d'indices, precisely because it's very difficult to obtain this kind of proofs. They also tend to draw adverse inferences, as in the example that I was given, when a party refuses to produce some documents. But there is also something very interesting, which is, and it's very exceptional, but I think it's very interesting to mention, which is the fact that some tribunals have reversed or have shifted the burden of proof when it comes to these kind of allegations. They take the premise that once one of the parties had presented enough indicia that there may be something fishy in the transaction, then it would be for the other side to disprove this indicia by proving the legitimacy of the transactions of the underlying contract. But again, this is quite exceptional, but I think it's a useful tool for tribunals when they really want to go into the end and dig and see if the contract was obtained by fraudulent means or not. The third topic I wanted to raise is whether, because when the parties raise these claims, then the tribunal have no choice but to address this issue, which many tribunals, as I was saying, sometimes they prefer to hide themselves behind a very high standard of proof to get to a finding, to prevent them from taking a positive determination. But there are some cases where the parties have not raised these questions, or when the parties have presented the issue in a way that they have not really raised these claims. You know, there's a paper coming to me. Okay, 2 minutes. So what can a tribunal do? Should the tribunal decide the case only on the basis of the parties' allegations, or can the tribunal go further and seek further to see if there was any illicit means when the tribunal smells that something was wrong? There are two major principles in international arbitration that may clash. On the one hand, you have the New York Conventions that allow to refuse recognition of awards in case of awards that are against public policy, which could be the disregard of an issue of corruption. But on the other hand, you have also the New York Convention that would also allow the refusal of recognition when the award contemplates issues that were not submitted within the terms of submission from the parties. So it's a very delicate balance. In my opinion, all things considered, the relevance of public policy considerations should take precedence over all other principles, as long as the tribunal ensures that due process, of course, is not affected and that all parties have a fair opportunity to present their cases. And the very last point I wanted to mention was about what are the legal consequences of these findings. It's clear there are many instrument treaties. There is a United Nations Convention on this subject that expressly states that states should incorporate in their own internal rules the possibility to annul and declare void any contract obtained by these fraudulent means. But that is quite simple. Most tribunals have incorporated that and have considered these laws and treaties as part of the transnational public policy. But there's one consideration to be taken into account, that it may happen that just the fact that, okay, there's corruption, the contract is annulled, but there's one consequence, that it may be that the party that was involved in that illicit act could at the end benefit from the fact that you will not have to, for example, reimburse any money that they paid as bribes because of the finding of the tribunal that the contract was obtained by illicit means. So I'm going to read very briefly, and with this I'm finished. There was a case with all this happens, commissions were paid in order to bribe state officials. So the tribunal found all this, the dismissal claims, and then they said that as the respondent, who was the party that paid the commissions, knew that the purpose of those commissions was precisely to bribe state officials, it could not recover any monies paid under that agreement, since what has been given with illegal intent cannot be reclaimed under theories of equity or unjust enrichment. Thanks.
Thank you, Christian. Thank you very much. Again, from our audience, any questions for Christian on corruption? We have one. Could we have the microphone over on this side of the room, please?
My name is Musa Mwenye. I'm Attorney General Designate of the Republic of Zambia. Now, my contribution is in two parts. In the first instance, I just want to share an experience with respect to corruption and how we've dealt with it in our own contracts. I think, and I would invite a comment on that one. We have provided in our contracts as a government with contractors and investors an extensive clause on the avoidance of that contract on grounds of corruption, should we later on find as a fact that there was corruption. And we've invited repercussions of corruption into those contracts. By that means, I'll invite a comment on that one. Secondly, it's also with respect to tax evasion. Would you have any comment with respect to tax evasion that is found as a consequence of arbitration proceedings?
No, I'm not, about the issue of tax evasions, I'm not aware of any. I think that would fall more on the criminal aspect, and I'm not aware of any arbitration dealing with that topic. I don't know if my colleagues in the panel are aware of a precedent like that.
That's fine. I think that there are some issues to do with arbitration and money laundering, which are very big ones, and I don't think we've got time for them now. Any other questions about corruption for Christian? It's clearly not an issue in this part of the world. So perhaps with that we can move to our final speaker, who is our final speaker for no reason of precedence. On the contrary, Professor Kostin is one of Russia's most distinguished academics. He's also a leading figure in arbitration here, and he's president of the International Commercial Arbitration Court at the Russian Chamber of Commerce and Industry. The reason that Professor Kostin is speaking now is that he's been able to hear these contributions from around the world, and I'm very keen to have a contribution from him that takes them into account, particularly in advance of the further sessions that are going to happen later in the day on the Russian court system and also on Russian arbitration. Professor Kostin, thank you.
Thanks a lot, Mr. Chairman. Good afternoon, distinguished ladies and gentlemen. With your permission, I'll continue in English. The explanation is that, my Russian colleagues would have chances to address and to meet with me here, and my main goal is to share some views with the distinguished colleagues here who might be interested in what's happening in Russia with regard to arbitration, and what are the views of Russia about arbitration worldwide. So this is my intention, so I'll try to do something within this nutshell time. Well, the focus of this seminar, of this section, is the 21st century. Like a lazy student who was asked to speak on England, and then he didn't know England well, and he started, well, let me begin with the neighbor country, France. So I'll speak very little about the previous century, to understand what's happening and what we are anticipating in the future. Well, before 90s, last century, I would say that we had the golden age, the renaissance of arbitration, though we were at the Soviet times, and we had the monopoly of foreign trade. Interestingly enough, that at that time, any foreign trade contract concluded by state-owned enterprises had an arbitration clause. And not necessarily referring to arbitration in the USSR, but to some other decent places like Stockholm, sometimes at that time London, sometimes in the countries of the Council of Mutual Economic Assistance. There was a prototype of President European Union. That's fine. And when the awards were issued, there was no problem with setting aside. There was no setting aside procedure. In fact, there was no law on arbitration. No problem with enforcement. Since all the awards by the Soviet parties, the Soviet companies, if I might say so, were voluntarily executed. The different picture we had beginning 90s, when there was a development towards a new socio-economic system, towards the market economy. And at the Soviet times, there were two arbitrations which survived. I now had not only of the International Commercial Arbitration Court, but for a couple of years, also chairman of the Maritime Arbitration Commission at the said chamber. They were established beginning 30s last century, and are still active during present times, and de facto, the jure, they had, well, the monopoly. In this sphere, no other permanent court could have been established, no legal ground. Hypothetically, domestic arbitration was possible, but not demanded. Now the new times came, and now we have the opposite picture. We have several thousand permanently acting or, well, established or pretending to be permanent acting arbitration bodies. Several thousand, perhaps the figure is close to what had been referred to by our Irish colleague with regard to BIT. Some is telling 2,000 or 3,000, and they could engage in domestic and international matters without sometimes the required experience in the field of international commercial arbitration. Fortunately enough, we managed, and the lobby for international commercial arbitration managed to persuade our parliament to adopt the model law, the ancestral model law. Well, in fact, we are perhaps the most closest model law country, or perhaps have been for some considerable time. And some deviations are very small. If I could have some additional 2 minutes, I could explain. So the reason was very simple. The idea is, and I still, well, maintain the idea, that if it were possible for historical reasons to have dual regulation, one for international and second for domestic, it's better to do so, since we have a, well, understandable international standard for arbitration. And, well, of course, we have now from 2002 year the law on domestic arbitration, and we managed to persuade, well, our parliamentary members to have it separate. It's more simplified, and, well, after the experience would be growing, there we can get the unified law. I would not speak about the reform, where I understand we will have in the afternoon, well, in the after-lunch session, the discussion on the reform in this field of arbitration. It's not very easy, and the biggest question, which is better, one or two? One law or two laws? Well, the arguments of neophytes, I'm sorry, there are people who just started by thinking that they know everything about arbitration. They think that one is better than two. I'm against this approach. I think that our tradition in this country is a dual tradition. And by the way, most CIS countries followed the example. They had the same history with arbitration. And very simply, I don't think it's reasonable to make often changes to the law, which makes the situation unstable, which is very important in the field of international trade and arbitration specifically. We will see what will happen. Well, the new laws on arbitration, international and domestic, are supposed to be endorsed by the 1st January 2015. So we'll see. Some matters are still debatable, and there would be some hearings in the parliament. So I try to be optimistic, thinking that some portions of the law could be polished during the discussions within the parliament. And now the second part of my presentation is the views of the arbitration in the global format. Well, we feel, and we are, we feel that we are part of the international arbitration community. Well, my colleagues from the traditional eldest courts and new generations are very active in different formats, well, within the Arbitral debating, well, the transparency rules for treaty arbitration, well, in the working group for online arbitration. And of course, well, just to show that the questions of implementing new technologies within the arbitration is very important. While the new version of the Arbitral model law, well, takes into account this issue with regard to the form of the arbitration agreement and so on and so forth. The online arbitration is very important, and one can think where to stop. If we logically would protract the idea of online, then where are the people? Well, where are arbitrators? Well, sometimes it would resemble some playing the games with the computer, and well, some imaginable money or other assets are at stake. So it's very important, and in this line, I'm of the opinion that the arbitrators in the community around arbitration should think about sustainment of the original criteria of arbitration: effectiveness, timing, cost effectiveness, confidentiality. Unlike the investment arbitration, many people still think that confidentiality is an attractive criterion for arbitration. And in this line, also would like to mention that there are trends to make arbitration overcomplicated. It's against the primary idea of arbitration to be understandable, simple, and the quality which is guaranteed by the arbitrators. Well, it's an old saying that arbitration is as good as arbitrators. And in our strategy, in our policy within, well, the eldest arbitration courts, we are trying to focus on this, on the human dimension. Who are the arbitrators? We have the list which is not imperative, but like plat de jour for the parties to pick up, to elect people from the list. There are many prominent foreign lawyers. We like to be truly international, and parties can choose outside the list. I took note of that my distinguished colleagues spoke about price and quality balance, then cultural differences. Well, we understand in Russia this question of cultural differences. We are a very multinational country, and we used for centuries to work. We are, by the way, we are a Euro-Asian country. And so we have different relations, and we of course, have understanding about the importance of this dimension. This is, of course, very interesting. And, well, this tendency to try to struggle against further bureaucratization of arbitration is visualized now not only in this state, but in some states when a party or the parties receive some 200 or 300 pages award. And I know of the examples when even English judges are complaining that, well, the arbitrators are overdoing their thing. One can think why it's so. Well, somebody would think that this is the result of the hourly paid system. unlike the lump sum payment, but it's only a presumption. This is not a statement that this is so. And to conclude with, I'd like to say that I would love to make an impression that the Russian arbitration is not very different from other countries with developed arbitration systems. We have a culture of arbitration. And just I'll try to bring you at least 2 examples when, these ideas were somehow accepted in some very distinguished jurisdictions like England. Quite recently, a couple of years ago, while distinguished Wieder van Vechten, or commonly known as Johnny Wieder, Queen's Counsel, made a report and then made an article which was published in the Russian language in the Review on International Commercial Arbitration, edited here in Russian. And I do not cite the name of the article, but it's very interesting about migration of arbitration ideas. Here's an example like a Greek-Italian monk traveled to Moscow in the 16th century during John the Terrible time. Then how English ideas migrated to India and Pakistan. And he concluded then that one idea migrated back to London when the present law draft was discussed, and one case decided by presently the International Commercial Arbitration Court influenced, well, at least Johnny Wieder so saying, influenced the idea of separability of an arbitration clause in the present act. Influenced by the, not only by this award, but the enforcement procedure in Bermuda. I refer to the case Союзнефтеэкспорт against Jokoil Limited, Bermuda. And many people, well, and people in the House of Lords, well, recognized the very simple idea which was brought by our countries. And I'm concluding, and he also mentioned that the idea of emergency arbitrator for security measures. Well, such roots could have been traced to the beginning of 30s, when it was established that the president of the International Commercial Arbitration Court, the Maritime Arbitration Commission, could impose security measures by himself before the composition of the tribunal. And these powers are still present, and I can be asked, and I can give the security measures. I am sorry for being not very complete and balanced, but anyway, it's very difficult to be the last barrier before the people on the lunch. Thank you.
Professor, thank you very much for that very wise speech. You've done a good job of selling Russian arbitration, and from what I've seen, you have a good product to sell, and certainly a potentially excellent product to sell with some of the changes that are in prospect. One of the points the professor made that struck me most was that Russia is a Eurasian country, and we've heard about cultural differences. Maybe Russia has got a unique place in the arbitral spectrum in being able to bridge those differences and show us common lawyers how the best features of all systems can be embodied here. I'm conscious, for example, that the Supreme Commercial Court recently moved towards a system of precedent alongside commercial codes. It may be that Russia, again, in that regard, has a unique ability to take forward the next evolution of arbitration. Those are our presentations. I hope that you would join with me in thanking our speakers. And likewise, I can almost let you go to lunch. Before that, I'm asked to mention that there's a session at 1:15 right next door on reform of arbitration in Russia, or at least on commercial arbitration in the Russian Federation, trends and prospects. That's 1:15 next door. Thank you very much. You're welcome. Thank you.